All right, welcome to the Carl Jackson Show. This is your daily dose of objective truth in a world of confusion and lies. I hope you had a wonderful Easter weekend and a Resurrection Sunday. It was a great weekend, a great time for reflection. I know many people are upset about the what is it, the Trans Day of Vigilance. But guys, let me just offer a word of caution. I don't think there's anything the left wants more than for us to pay more attention to that day than to our resurrected Lord Jesus Christ. So maybe I'll talk about that in a later podcast. But I'm not going to get so caught up on that to give them more attention than they frankly deserve. I think that's what the left wants. I think they want to put us on the defense and have us defending our Lord as opposed to them defending mental illness, quite frankly. So anyway, but without any further ado, here's what I wanted to do. I wanted to do something a little different, or start off this week a little different. And this will air also later on SNC TV. But what I wanted to do, there are some very important cases, obviously, that the former president, Donald Trump, is tied up in. And what I wanted to do is just go a little further into that. So we've invited Zack Smith. He's a frequent guest and a constitutional attorney that works for the Heritage Foundation. And he writes articles for them. Yeah, I mean, studies, research, you name it. Just go to heritage.org, dailysignal.com. You can see his work there. He and other attorneys as well. But I just wanted to get his take on some of these major cases so that it isn't just me sounding off on, oh, they're persecuting Trump or this or that. I want to know, legally speaking, maybe where Trump is safe, maybe these cases go overboard, or maybe there are some issues that we need to pay attention to, regardless of whether or not we believe, as I do, that the man is being persecuted, frankly, unfairly. And I do use that word persecuted. But at the same token, I have to understand what's happening in the courts. So that's why we have Zack Smith on. Zack, thank you so much for joining us today. Really appreciate you taking the time to do so.
Of course. Always a pleasure to be with you, Carl, and I appreciate you having me back on the show.
Absolutely. Okay, so let's do this if we could, Zack. Let's start with what I think is probably the most important case, and dare I say maybe dangerous case for Trump, even though I believe it is persecution. I actually read through an article from the Epoch Times, and you know, and honestly, I mean, they're a conservative outlet. There's no doubt about that. But as I read through some of their work, I sat there thinking, okay, we can't just dismiss this case outright, as much as I would like to, as much as I think that there's been unfair treatment between Trump and Joe Biden, the sitting president. So the Supreme Court is set to hear these arguments on April 25th. And you have here, Zack, that Trump's appeal is arguing that he is immune from criminal prosecution in this case brought by Special Counsel Jack Smith. If you'll just give us a general, I guess, answer to your thoughts on that, and then I'm going to go in with some specific questions.
Yeah, no, I think this is certainly one of the most closely watched cases, Carl. And as you mentioned, it involves the question of whether or not Donald Trump enjoys immunity from criminal prosecutions for actions that he says he took in his official capacity in the aftermath of the November 2020 election. The U.S. Supreme Court has scheduled oral arguments in this case on April 25th. It's set to be the last case the court will hear arguments on this term. And I suspect it's going to be one of the most closely watched cases the court is going to hear this term because, frankly, it could have vast implications for presidential power for parties of both, the presidents of both parties going forward, essentially. And what Donald Trump is saying, he's saying that the actions he took in the aftermath of the 2020 election were within the outer perimeter of his official duties. Now, we don't know exactly what that outer perimeter is. We don't know where the court would draw the line because this is really something that they have not had to address before. Now, what's interesting is there is a case from many decades ago involving Richard Nixon. It's called Nixon versus Fitzgerald, where the Supreme Court...
You beat me to my next question. This is how good this guy is.
Well, let's see if you still say that. But it's But Nixon versus Fitzgerald, it's a case where the Supreme Court previously held that presidents enjoy absolute immunity from civil suit for actions they take in their official capacity as president. So what Donald Trump is doing, he's essentially analogizing to Nixon versus Fitzgerald and saying that presidents should enjoy that same type of immunity from criminal prosecution. Now, the lower federal courts, the district court judge there in D.C., Tanya Chutkan, she's rejected this immunity argument. The D.C. Circuit Court of Appeals, they have also rejected this argument. You may remember there was some procedural shenanigans, if you will, earlier where Jack Smith essentially tried to skip the D.C. Circuit, go straight to the Supreme Court because he was, I think, trying to get this trial started and over with before the upcoming presidential election. But the Supreme Court rejected that effort, said, no, we're going to do things in normal order here. And so the D.C. Circuit heard the case and issued quickly, not unduly hastily, but pretty quickly issued an opinion rejecting Donald Trump's claims. And so that's why he is back before the Supreme Court now. Now, one more thing I will note, Carl, that's interesting is this case primarily resolves around presidential immunity. It doesn't really touch the underlying merits of the charges that Special Counsel Jack Smith has brought. And so one of the very interesting scenarios that I've heard several other legal commentators raise is that it's a very real possibility that Donald Trump could lose on his immunity claims before the Supreme Court, but still prevail on future legal challenges to the underlying charges that Jack Smith is being brought against him, because those charges themselves are legally questionable. And so if that happens, obviously this is not something that would be resolved quickly, but it is something that I think we should pay very close attention to. And I suspect we may get a better indication of where things stand or where some of the justices are thinking on this particular case once we hear our oral arguments in the case on April 25th.
All right. I mean, just a wealth of knowledge here. Let me circle back if I could. There's something that you mentioned that I actually read in a column that I was kind of surprised to hear. And so I want you to dive a little deeper on that. And then also the Nixon versus Fitzgerald. Just for clarification, they were arguing then that this was a civil liability case, whereas Trump is a criminal case. Is that why Judge Chutkan just said no? This doesn't work. I mean, does she have a legitimate argument? Does she have a legitimate gripe? I've always taken her as someone that's just being vindictive and of the left. And this is something she was going to do anyway. But is there a legitimate gripe, civil liability, as opposed to what they're trying to get Trump on? And that's what they're alleging is criminal liability.
Yeah, so Nixon versus Fitzgerald does not directly apply to this situation because it is a criminal case as opposed to a civil matter. And so essentially what Donald Trump is doing, he's asking the court to extend the reasoning, extend the rationale in Nixon versus Fitzgerald to cover this situation. Now, what Jack Smith, the special counsel, is saying, he's saying criminal prosecution, civil suits are two entirely different things. And again, we'll have to wait and see whether or not there is some sympathy for that position among the justices on the Supreme Court. One of the other interesting things I think will be interesting to watch, Carl, is several of the current sitting justices have pretty extensive executive branch experience. Not only executive branch experience, but experience in the White House. Keep in mind, Justice Brett Kavanaugh, he served in the Bush White House.
That's right.
So he has a very close upfront view of the inner workings of presidential power, how it works in practice. Samuel Alito was also a high-ranking government official in the Bush administration. Elena Kagan has previously served in high-ranking government officials. And so we've heard this kind of come out in some of the earlier statements they've made from the bench this year, particularly in Murphy versus Missouri, which was the case where several states were challenging actions the Biden administration had taken, trying to essentially strong-arm social media companies to take down posts they disagreed with. And we heard Justice Kagan, Justice Kavanaugh draw on their own experience serving in the executive branch as they were asking questions at oral argument in that case. And I suspect and would be curious to see whether something similar happens in this case as well.
Okay, so we only have about a minute left in this block. And here's what I'd like to ask you, Zach, and you mentioned it. Trump is arguing that what he did on regarding this case in round J6 was on the outer perimeters, if you will, quote unquote, of his, I guess, executive power. That it seems so simple, but that kind of surprised me that Trump's attorneys would argue from that perspective. That kind of let me know that, I mean, they are taking this thing very seriously. Your take. We only have about 40 seconds, but that wording kind of surprised me, to be honest with you.
Well, to enjoy immunity, it has to be an official action. If it's an action that's taken in a private capacity or a political candidate, typically those types of actions would not enjoy the same type of immunity. Now, there is another interesting case where Donald Trump is facing civil suit from Capitol Police officers, where essentially the D.C. Circuit Court of Appeals in that separate case found that his actions in the aftermath of the 2020 election did not fall within that outer perimeter. But again, because this is an unprecedented situation, because we've never had a former president facing criminal charges before, we don't really know where that line of that outer perimeter falls.
Let's leave it there. We'll be right back with Zack Smith. All right, welcome back to the Carl Jackson Show. Again, your daily dose of objective truth in a world of confusion and lies. Guys, I just want to remind you that today's show is brought to you by MyPillow.com. Mike Lindell has built a fabulous company in MyPillow.com. Right now, they've got amazing deals available for the new MyPillow 2.0. I encourage you to go to MyPillow.com. Click on the radio podcast square at the top of the page, enter my name, Carl, C-A-R-L, and you can check out that deal and all of the deals that are available to you if you use the promo code Carl, spelled with a C, or give them a call, 800-858-0263. There's no doubt the left have been going out of their way to try to destroy Mike Lindell and his company with American-made products, and he's providing American jobs. Don't let them do that. If you're going to buy products already, Father's Day is coming up, Mother's Day is coming up. Look on MyPillow.com and see what you can grab. And also, all of these products, many of them are going to help you get a great night's rest. And Lord knows we need rest in these crazy times. All right, I want to get back to my guest, Zack Smith of the Heritage Foundation, a constitutional attorney. His resume is insane, so we would take up the whole time, this whole block, just reading through his resume. So instead of doing that, I'll just say, listen, he's a great attorney, constitutional attorney at the Heritage Foundation. Make sure that you read his work at heritage.org, a daily signal.org. He always puts out fantastic stuff, as well as the other attorneys there on staff. All right, so we are talking about this presidential immunity case with Jack Smith, and we'll get to the other cases. I want to get to the, and I forget the name of it, the Missouri case as well here, Zach, that you just mentioned on censorship, and get, a little more of your take on that. But I want to get back to this immunity case with Trump because, I felt like this case should be a walk in the park, so to speak. But the more that I read about it, even though it is unprecedented, I mean, this case will have no doubt major implications. And given the fact that this case is being tried in the Beltway, if you will, I mean, listen, again, this case. Yeah, I just don't want to dismiss it outright. And that's what I was doing. I was like, listen, these guys are persecuting Trump. And I'll be honest with you, I still feel that way. But as I dive into the legalese of this and I listen and read people like Zach, this isn't something that we can dismiss outright. Okay, so we were speaking of before we went to the break. I mean, you talked about how Trump mentioned the outer perimeters of this case, and there was this case against Donald Trump by the Capitol Police, Zach, where basically he didn't win, and that's the same argument. He's making the same arguments here. And again, no doubt, regardless of how you feel about the case, I mean, this is unprecedented with the former president, and this will have major implications going forward. The circuit court also ultimately rejected President Trump's immunity request in a unanimous decision. Does that tell us? I mean, I'm assuming they wouldn't have that type of pull on the Supreme Court, would they? The Circuit Court?
Well, basically, what would happen is, Donald Trump, I'm sure, will appeal that decision, ask the U.S. Supreme Court to review it. But what's interesting in that case is because that case is a civil case. It's a civil lawsuit for damages, essentially. So Nixon versus Fitzgerald would be more directly applicable in that case. And yet, even though that Nixon versus Fitzgerald case that previously talked about presidential immunity, the court essentially rejected the immunity claim there. And so in that sense, that certainly doesn't bode well for Donald Trump. Now, of course, the D.C. Circuit Court of Appeals also ruled against Donald Trump in this case, this criminal case that he's currently asking the Supreme Court to review. And so just because he lost at the D.C. Circuit Court of Appeals doesn't necessarily mean that if the U.S. Supreme Court decides to take it up and review it, that he would lose there either. But certainly, look, Carl, one of the reasons this immunity exists for presidents when the Supreme Court first considered the question is that we don't want the president looking over his shoulder, second guessing every decision that he makes. We want him to be able to fully and fairly evaluate the options before him. He's often doing so with less than full information, having to make very quick decisions. And so we don't want him either being essentially gun shy, if you will, not seeking advice that he otherwise would have sought in making those decisions. And so again, whatever the court decides in this case is going to have, as you mentioned, vast implications for future administrations of either party going forward, where I suspect if the immunity claim is denied in this case, we may very well have presidents second guessing, looking over their shoulders, taking those, steps that we may be worried about that would delay them from acting, forcefully and efficiently in appropriate circumstances.
Yeah, I mean, I got to be honest with you, Zach. In my opinion, this case could absolutely destroy the office of the presidency. Here's something that I read, and I'm just quoting. This is from the Epoch Times column that I mentioned earlier. It says here, President Trump has argued that immunity should extend to alleged criminal acts. Special Counsel Jack Smith and the U.S. Court of Appeals for the D.C. Circuit were concerned that widening the scope of immunity that far would undermine the separation of powers and allow presidents to get away with egregious wrongdoing. And I understand their arguments, and I do think that it would destroy the separation of powers in the sense that, again, basically, I mean, as you imply, I mean, this would have major implications on the presidency. I, for one, think that it would destroy the presidency. And I'm concerned about who gets to determine what a criminal act is going forward outside of something egregious and obvious like murder or rape or something of that nature. I don't see how they could rule against Trump and the country ever be the same, Zach.
Well, look, I think it's important to put this separation of powers claim in context, Carl. The Constitution itself explicitly contemplates a mechanism for holding a president accountable when he or she potentially has violated the law. It's the impeachment process, right? I think everyone agrees that a president could be impeached, removed from office, and then at that point, face criminal prosecution if an alleged criminal act occurred. But in this case, we had multiple attempts to impeach Donald Trump. Some of the impeachment articles were based on the same conduct that he is now being criminally prosecuted for. And yet the Senate, which sits as the trial body in impeachment proceedings, actually acquitted him of that conduct. They didn't find him guilty of it. And so now to have the Justice Department under his chief political rival moving forward with these charges is very, very troubling. Personally, I think it's very bad for our country, and we'll have to wait to see how all of this plays out. But certainly, again, vast implications for the presidency itself. One other thing I'll mention quickly, if I can, Carl. I don't think it's gotten a lot of attention. There are a number of amicus briefs that have been filed in this case, friend of court's brief, that basically flag different issues for the court that maybe the parties themselves didn't brief. One very interesting brief that was filed, it was filed by former Attorney General Ed Meese, several law professors as well, Gary Lawson, Steve Calabresi, and some other folks who are well-known conservative legal law professors. They filed a brief essentially arguing that Jack Smith's appointment as special counsel itself violates the Constitution. Now, I don't think this is something the court is likely to take up in this case, but that's something to look carefully at, because we're seeing more and more special counsels being appointed, dealing with a range of issues. And so I suspect that issue, if the court doesn't address it in this case, may be ripe for the court to address in a future case.
Yeah, that is absolutely right. I've forgotten all about that, but I do recall that. I think Ed Meese argued that Jack Smith didn't have the authority to bring this case in the first place. Am I? Is that the gist of it?
Essentially, because his appointment was unconstitutional. Yes.
Okay. All right. Good stuff. All right. Smith is also, his indictment alleges that Trump attempted to fraudulently forestall congressional proceedings on January 6th. I mean, in another, I guess he's arguing, or the DOJ is arguing that Trump's activities leading up to January 6th, as well as whether his actions constituted attempts to defraud the United States. How is that even possible? I mean, how is that even possible? I mean, it's as if they can read his mind. We have less than a minute left in this.
Yeah, well, it goes back to what you were saying earlier, what we were talking about earlier, Carl. Look, even if Donald Trump is to lose on the immunity claim in this case, there are very real, very substantive issues regarding the substantive charges that Jack Smith has brought against Donald Trump. And I suspect, regardless of what happens at any trial, there will be issues that the appellate courts, maybe even the Supreme Court, will have to review if and when these cases do, in fact, go to trial.
Okay. All right. Again, I'm speaking to Zack Smith of the Heritage Foundation. Make sure you check out his work at heritage.org. Our Daily Signal. DailySignal.com is basically what I get in my inbox every morning, and I comb through it as well as other outlets. Very good stuff to have. We're going to be back with Zach. We're speaking about President Trump's immunity case, but also I want to get on to the Fulton County cases as well as others. So we'll be back with more. Stay tuned. All right, welcome back to the Carl Jackson Show. Again, I'm joined by my guest, Zack Smith, constitutional attorney for the Heritage Foundation, and we're talking about all of these Trump cases where we'll be ending, or I won't say we'll be ending. We're talking about the immunity case. I think this case has some of the larger implications, and I think could be the most dangerous, perhaps, to the country, to the separation of powers. But we'll move on to some of the other cases that Trump is involved in as well. But I got a couple of quick questions that I want to ask our guest, again, Zack Smith of the Heritage Foundation. Again, presidential decision-making is on the line. There's no doubt about that. The issue of presidential immunity and the Presidential Records Act, in your opinion, let me ask you this. Let me ask this way, Zach. If you were Trump's attorney, what would you be arguing on his behalf?
Well, if we're talking about the Presidential Records Act issues, most of those come up in the Florida case that he's currently facing in front of Judge Eileen Cannon in the Southern District of Florida. And I think it really depends, about how that case is going to set up as it heads into trial. One of the most recent debates in that case was over the jury instructions that the judge was going to give to the jury. And certainly many of these issues around presidential immunity, some of those exist in that case as well. But what's interesting in that case, that the issues in that case cut more directly to the heart of presidential power, because one of the claims that Jack Smith is making in that case is essentially that Donald Trump took classified documents or documents marked as classified to Mar-a-Lago with him. Well, the president, under Article 2 of the Constitution, has broad inherent authority and can decide whether or not to classify or not classify those documents. And so I suspect in that trial, if the jury finds that Donald Trump, in fact, declassified those documents before he took them to Mar-a-Lago, then in that case, that would essentially undercut that entire prosecution. And so a lot of very interesting issues being raised in that case as well. But I don't think the issues in that case are quite as pressing and moving as quickly as they appear to be in this D.C. case that the Supreme Court is currently set to consider at the end of April.
Okay, so one of the things that I almost forget about. I have to be honest with you. There are so many cases being thrown at the former president right now, and strategically so. I almost forget about the Florida case, at times, and so I'm so glad that you mentioned that, because obviously that'll have major implications as well. And I don't know. I honestly, I get so caught up into these headlines, the Fannie Willis case, the Alvin Bragg cases. I mean, these cases that are absolutely ridiculous, and we'll get into those in just a second. But it seems like, at least to me, that the case in Florida, if you will, Zach. I mean, I don't know how else to say this, except, at least from my point of view, is the judge there takes the rule of law seriously. This doesn't seem to me to be a case where the judge, and forgive me, I forget her name.
Judge Cannon, Eileen Cannon.
Judge Cannon, thank you, Eileen Cannon, thank you. It doesn't seem to me. She seems like she's being totally fair. Is basically what I'm trying to say.
Well, she's gotten a lot of grief because of that from the mainstream media. But look, she's certainly not a rubber stamp for everything that Donald Trump and his lawyers want. In fact, she just denied one of his motions to dismiss the case. And so this idea that she's somehow bending over backwards for Donald Trump, trying to, skew the table in his favor, as some on the left have said, that's just not true, of course. Now, I think one of the things that has frustrated Jack Smith and the Justice Department in this case is, certainly they're trying to, again, push all of these cases to trial very quickly, trying to get them to trial before the upcoming election. And Judge Cannon has been very careful to cross her T's, dot her I's, make sure that everything is being done by the book. And she's not giving in to pressure from Jack Smith and the Justice Department to unnecessarily rush this case. And so, again, we'll have to wait and see what happens in this Florida case. But, with the D.C. case being at the Supreme Court, that is certainly front and center on everyone's minds right now.
Okay, so here's a question that I have for you. We have just over 5.5 minutes left in this block. How much can courts review is a question that I would have. Let me just read part of this column and get your response. Again, I'm speaking with Zack Smith, constitutional attorney for the Heritage Foundation. Check him out at heritage.org, dailysignal.com. And you're also on X, aren't you, Zach? Okay, so what is your account?
Sure, it's at TZ Smith. At TZ Smith.
All right, and I follow him on X, so I'm like, but I had a brain freeze there. So at TZ Smith. All right, so presidential immunity, the column says, has historically been understood as an integral part of the separation of powers between the three branches of government. For practical and constitutional reasons, judges have resisted the idea that presidents can be tried for certain actions in the court established under Article 3 of the Constitution. So, I mean, how much? That is a good question. How much can courts review in the first place here, Zach? Because how is it that it seems to me that the judicial branch can essentially nullify the executive branch?
Well, certainly the separation of powers concerns, as we were talking about early, underline many of the issues in these cases. And so one of the things we were talking about, the outer perimeter of Donald Trump's authority as president, what exactly that means, that can be very important. And it'll be very interesting to see what the court decides to do with that question, because if they decide that Donald Trump was acting purely in his personal capacity, if they decide he was acting purely in his capacity as a political candidate, those actions likely would not enjoy immunity. But if they decide that he was acting in his capacity as president of the United States to make sure that rules and procedures regarding elections were followed, to make sure that the vote count was accurately conducted, those types of actions, those actions historically have enjoyed some degree of immunity. And so again, all of these issues, Carl, are unprecedented and really without any legal analogy in our history, because never before has a former president faced these types of criminal prosecutions.
Yeah, and I'm fearful. I am concerned that the left could do a whammy on this because even though it's unprecedented, I know, obviously Jack Smith will say, well, a president hasn't started a riot or an insurrection before, even though, it wasn't an insurrection. It's absolutely insane to me. But the Constitution is rather vague on presidential immunity. Am I right about that? Or
that's right. It's not explicitly mentioned in the Constitution. It's derived from the president's inherent powers. The Constitution vests the executive power in the president of the United States, and so it's derived from that. It's not explicitly, there's not a presidential immunity clause, but this idea of presidential immunity is something that has enjoyed in varying degrees, has been well recognized and has a long history, dating back to the founding era, because it is viewed as being inherent in the president's authority.
And correct me if I'm wrong, but one of the things that Smith is arguing is that Donald Trump, during the January 6th rally or what have you, he wasn't operating in his capacity. And I know that I believe vaguely spoke to this earlier, but he wasn't acting in his capacity as a president, but more of a campaigner,
right,
if you will, or something like that. I believe I read.
That's right. As in his capacity as a political candidate, essentially.
Okay.
And so because of that, Jack Smith is saying that he does not deserve immunity.
Okay. All right. Well, let's do this. We only have a minute and a half left in this block. I don't know if Zach can stay with me or not. I'm going to ask him to, but he's a busy man. So if you say no, Zach, I completely understand. Let me just move real quickly. Trump scores a legal win as the New York Appeals Court allows him to post a lower bond in that civil fraud judgment, which I believe is a hoax of a case. In my opinion, we have less than a minute and a half in this block. Just give us your take on this case and the lowering of the bond in that particular case.
Yeah, look, it's certainly a win for Donald Trump. I think many people were shocked at the eye-popping number that was imposed by the trial judge in this case. And so I think there were very real concerns about, the nature of the case, the due process concerns, potential issues regarding excessive bail, excessive fines in this case. And so I think some of those were reflected in the fact that the appellate court in New York lowered his bond. And Donald Trump has said he's going to post cash for that bond. And so it looks like as this review of that case plays out in the appellate courts, which could take months, essentially the New York Attorney General won't be able to levy on his property in the meantime because he'll post this lowered bond.
And that case is so insane. I mean, just last week, Jon Stewart was caught. It was insane. He sold same exact case as Trump. And frankly, mostly everyone that has ever bought a home or commercial property, where literally the guy sold a property for, I think, $17.5 million, but he was still paying taxes on the assessed value of the property, which was only $847,000 while he was calling out Trump. Insane. Anyway, this is the Carl Jackson Show. Stay tuned. All right, welcome back to the Carl Jackson Show podcast and TV show. Zack Smith has agreed to stay with us for one more segment because I wanted to make sure that we got into all of the other cases that Donald Trump is involved in. And listen, guys, for me, this isn't an issue of this isn't just about Trump. I mean, what these people are fundamentally doing, in my opinion, many of the prosecutors that are going or attacking Donald Trump is essentially they are trying to restructure I think the rule of law, and unfairly so, and they're using the hatred that some on the left feel for Donald Trump in order to be able to advance their narrative and advance their agenda. So we were speaking about the civil fraud case in Florida just before the break, and I just want to continue on with that for just a sec, because as I mentioned, Zach, this stuff happens all the time. I'm not right or wrong. I mean, this seems to be the industry. Donald Trump was doing absolutely nothing there. And for Letitia James and this Judge Engoron to come in and literally, not just the money amount, but initially, And even still, I don't even feel like he should have to pay it. But to say, you know what we're going to do is just, I mean, we're just going to seize your assets. And you have people cheering for that. I'm like, whoa, if that happens to him, it's only a matter of time before it happens to people like us. We've seen these stories with squatters, regular homeowners and so on, et cetera. We're entering crazy town with some of these court hearings, are we not?
Well, you would certainly think that it would give pause to anyone considering doing business, particularly real estate business, in the state of New York, if the Attorney General is essentially going to come in, threaten to bring very dubious, very broad charges against you, and then seize your property almost as a political play. You know, keep in mind, we've talked about it before, Carl. Letitia James, the New York Attorney General, she essentially ran for office on a platform of, quote, getting Donald Trump. And now she's followed through, asked for a, record-setting sum to be imposed in this case. The judge essentially imposed almost what the Attorney General was asking for, not quite, but pretty close to it. And so now to see this playing out, I think many people are very troubled by it. You mentioned the valuation of property. One of the central issues involved was how Donald Trump has valued his property. Keep in mind, he received loans from very sophisticated counterparties, from very sophisticated banks in this case, who didn't object to these valuations. And in fact, at trial, it came out no one was harmed. Everyone was repaid of the loans with interest they received, and were happy to do business with Donald Trump and his, various entities in the future. And so it's a very odd situation where you essentially have the parties who are supposedly harmed saying that they weren't harmed, that they were happy to do business with Donald Trump and would do so again. And again, we heard conflicting testimony at trial about the valuations of some of these properties. There can be good faith disagreement about how some of those parties were valued. But you'd certainly think, Carl, that the entities lending millions and millions of dollars against these properties would be some of the entities best positioned to assess the true market value of these properties. And yet somehow, even though they loaned money against these properties, were paid back their money, said they weren't harmed by Donald Trump or his companies, somehow still Letitia James and this judge in this case found that, in fact, Donald Trump had acted fraudulently and imposed this absolutely eye-popping, record-setting fine against him and his companies.
Yeah, and I got to tell you, I mean, this is, in my opinion, this is why politics can be so dangerous. And I ask everyone out there, it doesn't matter what side of the aisle you're on. It's really important not to get so overly emotional on any candidate per se. That includes Donald Trump, and stick to the issues, because here's what the left does. What they do is they use emotion on the left, and they try to make their voters, their constituents or what have you, just absolutely hate Donald Trump. So common sense no longer prevails. I mean, common sense tells you Donald Trump could appraise his property for whatever he wants to, but he's got to get a loan from the banks, to build some of these things, or, whatever, improve them, sell them, buy them, whatever it may be. So the bank, if they're going to issue a loan, they're going to come in and say, I know you say it's worth this much. This is how much we say it's worth, our appraiser. And so this is how much we'll give you. And then ultimately both parties say, oh, okay, that works. That works for me. That works for me. I mean, this is just utterly insane. But I could go nuts in that story. It just plays on people's naivete, people's hatred against former President Trump, and it has major implications as well. I mean, ultimately, you will own nothing and be happy, as the left says. Okay, let me move on. We have just over 5 minutes left. I want to move on to this case with the Fulton County case. And with Fani Willis, and I know she's all of a sudden she's Fani. I'm calling her Fani still. I'm a fan of Fani. All right, so I'm a fan of that name. I'm not a fan of her. Anyway, this case is a complete and utter disaster. I don't understand how this judge says, Judge Scott McAfee, Zach, tell me how this is possible, how this thing isn't thrown out. When the judge says, okay, Nathan Wade, having you around gives us this, this look of impropriety and all of this kind of stuff. But we're going to keep the chick on that hired you. even though it looks like you may have been involved in corruption and you frankly lied on the court. But the lady that did the same thing, we're going to keep her on the case. How is this even possible? How is this lady even allowed to go forward with this case? This makes no sense to me whatsoever.
Yeah, it's a great question, Carl. Look, I think the judge in this case was trying to be very Solomon-like, trying to split the baby in some instance, if you will. And essentially, if you read his ruling, what he said is either Nathan Wade can leave the case, or if he stays on, the entire Fulton County District Attorney's Office has to be recused from the case. Well, of course, Nathan Wade shortly after submitted his resignation, and so Fannie Willis and her office is still moving forward with this prosecution. Now, as you mentioned, I think anyone who watched the trial testimony of Nathan Wade, his law partners, Fannie Willis, should be very troubled by what they saw and by what they heard. And so that's part of the reason I suspect, among others, that Donald Trump and the other defendants in this case are appealing the judge's ruling in this case, seeking to have the entire office disqualified. Now, if the entire office is disqualified, that doesn't mean that this case would automatically go away. There's an entity in Georgia that would essentially look at the case, reassign it to a different district attorney's office, and then they would nominally be charged with moving forward with the case. Now, I suspect, as many legal commentators have pointed out, this case is very weak. It's a very novel application of Georgia's RICO statutes. There are, again, underlying issues with the substantive charges as well. And so I suspect another prosecutor might look at it and say, we're not interested in moving forward with this case. Keep in mind, too, Fannie Willis's office has already been disqualified from pursuing the charges against one of the defendants in this case. She essentially indicted this case, including this one particular co-defendant, and then hosted a political fundraiser for his political rival. And so because of that, the judge said there's, at a minimum, an appearance of impropriety here, an appearance of a conflict of interest. And so we're going to reassign this one defendant, at least, to a different district attorney's office. But you're certainly right to be very troubled by this, Carl, because, again, I think anyone who watched that entire hearing should think that this is not the way a railroad should be run, and they would certainly be correct in that judgment.
Okay. Last question on this. We have 2 minutes remaining, and then I want to ask you quickly about this Murthy versus Missouri case. In your opinion, is it possible obviously, with the judge allowing Trump and his co-defendants to appeal the Fannie Willis disqualification decision, given everything that you've seen in the court, is there a chance at all that perhaps all of these defendants it could not only get rid of Fannie Willis, but ultimately prevail in such a way where they could have their charges dismissed? Is that even possible, or is that a far-fetched?
Well, it's certainly what they're hoping, what they're asking for in part. Look, I think first we'll have to deal with this recusal issue. Then even if the substantive charges move forward, this is going to be an incredibly complex and incredibly time-consuming case to try. And I suspect the way Fannie Willis indicted it is part of the reason it's so difficult, will be so difficult to try, but we'll certainly have to watch and wait and see. One other thing I'll quickly mention, if I can, Carl, we haven't talked about yet the Alvin Bragg case in New York City.
Yes,
that is set to go to trial actually later this month. It was supposed to go to trial last month in March, but the judge there actually delayed it because Alvin Bragg and his office dumped a substantial number of documents on Donald Trump and his team shortly after that. There's been a lot of back and forth in the media. This judge imposed a partial gag order on Donald Trump. Alvin Bragg and others are essentially asking him to expand that gag order now. But many view this as being the weakest case substantively against Donald Trump. I've written and talked about some of those issues in this case. But this one is set to go to trial later this month in April, and we'll have to wait and see what happens and if, in fact, this case does move forward and the trial begin at that date.
No, I'm glad you mentioned that. I literally had it, Letitia James, Fannie Willis, Alvin Bragg, and then Murthy versus Missouri. And I totally forgot to mention that. But that case is a disaster, too. But the fact that they're bringing it and being allowed to bring it so quickly obviously is meant to interfere in the election. Listen, Zack Smith of the Heritage Foundation, man, we appreciate you. We'll have to bring you back for more to go into that case in Murthy versus Missouri. But until next time, don't grow weary doing good. God bless you.